Iowa has a lightly regulated breaking lease framework with a statutory duty to mitigate, strong preemption provisions, and one of the longest anti-retaliation presumption periods in the country. The governing law is found in the Iowa Uniform Residential Landlord and Tenant Act, Iowa Code Chapter 562A, along with general contract principles. If you're a landlord or tenant in Iowa, the state provides a basic statutory framework, while the preemption statute ensures statewide uniformity. Let's start with the landlord's duty to mitigate damages. Under Iowa Code Section 562A-29, when a tenant abandons the property or breaks the lease, the landlord has a statutory duty to make reasonable efforts to re-rent the unit. Iowa's mitigation requirement is codified. The landlord cannot leave the unit vacant and hold the departing tenant liable for the full remaining rent without making genuine re-rental efforts. The landlord must take reasonable steps: advertising, showing, and accepting a qualified replacement tenant. The departing tenant's liability is limited to rent during the vacancy period plus reasonable re-rental costs. Advertising, cleaning, make-ready work. If the landlord fails to mitigate, the departing tenant's liability is reduced by the rent the landlord could have collected through reasonable efforts. Iowa's preemption statute, Section 364(3), limits local governments from regulating certain aspects of the landlord-tenant relationship. This preemption ensures that the breaking lease framework is uniform across the state. No Iowa municipality has enacted local provisions that add requirements beyond the state act. Des Moines, Cedar Rapids, Iowa City, and every other Iowa community operate under the same framework. This preemption is notable because Iowa City, one of the most politically progressive cities in the state, would likely have enacted additional tenant protections without preemption. The uniform framework means landlords can apply the same breaking lease procedures across all Iowa properties. Early termination clauses are generally enforceable in Iowa. The state does not cap early termination fees. A clause requiring 30 to 60 days notice and a fee of 1 to 2 months' rent is typical and enforceable. The fee must represent a reasonable estimate of anticipated damages. Iowa courts enforce reasonable contractual provisions, but will not enforce a grossly excessive penalty. Military members have the right to break a lease under the SCRA. Iowa's military population is relatively limited. The Iowa National Guard has facilities throughout the state, and Camp Dodge near Johnston is the primary Guard training facility. There are no major active duty installations. However, the SCRA applies to any service member renting in Iowa. Iowa does not have a specific state statute providing enhanced lease-breaking protections for victims of domestic violence in the same detailed framework found in states like Oregon, Washington, or Massachusetts. Iowa does have the Domestic Abuse Act, Iowa Code Chapter 236, which provides protective orders. However, the act does not include a specific provision allowing early lease termination. Domestic violence victims in Iowa who need to break a lease must rely on general contract principles, negotiate with the landlord, or seek assistance through advocacy organizations like the Iowa Coalition Against Domestic Violence. Including a voluntary domestic violence termination clause in your lease is a recommended best practice. Tenants in Iowa may break a lease if the landlord fails to maintain habitable conditions. Under Iowa Code Section 562A.15, the landlord has a duty to comply with applicable building and housing codes, make repairs necessary to keep the premises fit and habitable, and maintain essential systems including plumbing, heating, and electrical. If the landlord fails to act after receiving written notice, the tenant has remedies under the Act. Under Section 562A.21, the tenant must provide written notice identifying the deficiency. The landlord then has a reasonable period to make repairs. If the landlord fails to act within a reasonable time, the tenant may terminate the lease. For emergency conditions, particularly failed heating during Iowa's severe winters, the response time must be immediate. Iowa's extreme climate makes heating failures a critical breaking lease issue. When temperatures drop well below zero, which happens regularly during Iowa winters, a heating failure constitutes a genuine emergency. A landlord who fails to restore heat within hours creates an immediate health hazard and gives the tenants strong grounds for immediate termination. Iowa also recognizes constructive eviction. If the landlord's failure to maintain the property or affirmative actions, shutting off utilities, failing to address dangerous conditions, render the unit uninhabitable, the tenant can treat the lease as terminated. Iowa's one-year anti-retaliation presumption, the longest in the country, tied with Nebraska, is particularly relevant to the breaking lease context. Under Section 562A-36, if a tenant exercises any legal right, including making habitability complaints or contacting code enforcement, and the landlord takes adverse action within 1 year, retaliation is presumed. This extended presumption affects broken leases in 2 ways. First, a landlord who pursues aggressive damage claims against a tenant who terminated based on legitimate habitability issues faces the risk of a retaliation defense. The tenant can argue that the damage claim is retaliatory for the habitability complaint. Second, if a prior landlord provides a negative reference that appears connected to the tenant exercising their rights, the new landlord who relies on that reference in screening may be facilitating the retaliation. Iowa's abandonment provisions are found in Section 562A to 29A. If a tenant abandons the property, leaves without notice, removes belongings, and stops paying rent, the landlord can retake possession after following proper procedures. The landlord must provide notice, typically posting a notice on the premises and mailing notice to the tenant's last known address, before treating the property as abandoned. The departing tenant remains liable for damages subject to the mitigation duty. Iowa has a specific provision regarding the tenant's personal property left behind after abandonment. Under Section 562A-29A, the landlord must hold the tenant's property for a specified period and provide notice before disposing of it. This applies to broken lease situations where the tenant leaves belongings behind. From a practical standpoint, Iowa's rental market is concentrated in a few population centers, with the rest of the state having more limited activity. Des Moines is Iowa's dominant rental market. The economy is driven by insurance and financial services. Des Moines is one of the largest insurance centers in the world. Healthcare, government, technology, and agriculture services. When a tenant breaks a lease in Des Moines, re-rental times are moderate, typically 2 to 4 weeks for well-maintained units in desirable areas. The western suburbs, West Des Moines, Urbandale, Waukee, Ankeny, have strong demand with quick re-rental. Des Moines' growing immigrant and refugee population, including Bosnian, Burmese, Congolese, and Hispanic communities, adds diversity to both the tenant pool and the population of tenants who may break leases. Some of these tenants may break leases due to family relocation, economic circumstances, or cultural factors. Having clear early termination provisions and documented mitigation processes ensures fair treatment. Iowa City, home to the University of Iowa, has one of the tightest markets in the state. Student lease breaks time to the academic calendar fill quickly. Iowa City's progressive political environment creates more scrutiny of landlord practices than elsewhere in the state, even though the preemption statute prevents local regulation. Cedar Rapids has a moderate market driven by manufacturing and healthcare. Cedar Rapids was significantly affected by the 2008 floods and the 2020 derecho, both of which disrupted the rental market and generated lease breaks due to property damage. Landlords should be understanding of lease breaks caused by natural disasters. Waterloo-Cedar Falls has a market driven by manufacturing and the University of Northern Iowa. Ames, home to Iowa State University, has a tight student market. Sioux City has a moderate market influenced by meatpacking. The Quad Cities, Davenport and Bettendorf on the Iowa side, have moderate demand driven by manufacturing and healthcare. Smaller Iowa communities, Fort Dodge, Burlington, Ottumwa, Marshalltown, have more affordable markets with limited applicant pools. Re-rental in these communities can take longer. Meatpacking communities, Marshalltown, Storm Lake, Denison, have diverse tenant populations where lease breaks may be tied to employment changes in the processing industry. One best practice for Iowa landlords: include a clear early termination clause in your lease that works alongside the statutory mitigation duty under Section 562A-29. The clause should specify the notice period, fee, and process. Having a defined path encourages tenants to communicate rather than simply abandoning the property. Another best practice: begin re-rental efforts immediately and document every step. Iowa's statutory mitigation duty is enforceable, and your documentation proves compliance. Keep records of listing dates, advertising platforms, inquiry counts, showings, and acceptance dates. A third best practice: be aware of Iowa's one-year anti-retaliation presumption when pursuing damage claims against departing tenants. If the tenant broke the lease following a habitability complaint or other exercise of legal rights, aggressive damage claims may be viewed as retaliatory. Evaluate each situation carefully. The goal is to recover legitimate damages while avoiding retaliation exposure. Iowa limits the security deposit to 2 months' rent. The deposit must be returned within 30 days of the tenant vacating, with an itemized statement of deductions. If the landlord fails to return the deposit within 30 days, the landlord may forfeit the right to retain any portion. These rules apply to broken leases and normal move-outs alike. For the complete guide to Iowa breaking lease laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our Breaking Lease Law series.